Today I'm going to talk about what happens procedurally in state court. I'm not going to talk about what happens if you're in federal court from hearing to hearing, but I'm going to concentrate on state court, specifically about Minnesota since that's where I practice most. But this will apply generally to all other states as well. Other states might use a little bit different terms in terms of the meanings they'll use or never, but basically the procedure goes like this. The procedure starts with you either being arrested and being held in jail until you see a judge, and that usually happens for more serious crimes, or you'll get a ticket from an officer on the side of the road, or you'll be mailed a ticket or mailed a complaint or an indictment from a prosecutor or from a cop, and then you'll be told to appear at court for your first appearance. If you're taken into custody and you're in jail awaiting to see a judge, you'll be held, sometimes without bail, sometimes with bail. That first hearing you have in front of a judge in a serious case when you're in custody and taken straight from the jail to in front of a judge is usually what's called a bail hearing or initial appearance, where the judge will determine what amount, if any, bail or other conditions are necessary to make sure that you can be released into the public and to assure that you'll come back for the rest of your court appearances. If you're mailed a ticket or given a ticket on the side of the road, or you're mailed a complaint and they're just given a court date to come to, then your initial appearance will be used to inform you of what the charges are against you, and then you'll have an opportunity whether to enter a guilty plea or a not guilty plea in less serious cases. In more serious cases, you won't even be asked to enter a guilty plea or not guilty plea at the first hearing. But that first hearing is called an arraignment or first appearance. Generally, the purpose again is either to set bail if bail is required, or if that's already been done or is not necessary, then of course to inform you of what you're charged against. You have the right to have a complaint read to you aloud in front of the whole courtroom. Most people waive that right because most people can read and understand what they're charged with. But 150 years ago, only about half the population was able to read, and so people needed to come to court and have the complaint actually read aloud to them in the courtroom because they weren't able to tell on their own what they were charged with. So that's called an arraignment or first appearance. You have an option, of course, to receive an offer from a prosecutor at that arraignment or first appearance, and you can either reject that offer, ask for a continuance and ask to be appointed, court-appointed lawyer, which is called a public defender, or given more time to hire your own lawyer. Again, you can either plead guilty or enter a not guilty plea. If you don't plead guilty, then you'll be given another date, which is usually called a pretrial date. The purpose of the pretrial date mainly is to get an offer from the prosecutor and to start negotiating on the case to see if there's any sort of plea agreement that can be reached between you and your lawyer and the prosecutor that will resolve the case and will settle. Often that involves dismissing certain charges or amending certain charges up or down to get an agreement between the parties that the judge must then decide whether to adhere to or not. If the judge doesn't accept the plea agreement, you still proceed with your case. If you don't plead guilty at the pretrial, your next hearing is usually called an Omnibus or Rasmussen hearing. The purpose of that hearing is to find out whether any of your constitutional rights were violated. Things like whether the officer had a right to pull you over on the road, because sometimes they'll stop you when they didn't have the right to. Things like whether they had an illegal search of your vehicle or a legal search of your home or your office or a legal search of your person or your luggage or your belongings. Whether they had the right to take any statements from you. Maybe they held you in custody and didn't read you the Miranda warning, and they got some statements from you that are harmful to your case, and now you want to get those statements thrown out, or get any other evidence thrown out in your case because the police didn't follow proper procedures or because any of your constitutional rights were violated. A judge will then make a decision based upon your arguments that your lawyer makes or that you make for yourself. And then sometimes that leads in the whole case being thrown out if all the evidence is suppressed, and other times it only leads to some of the evidence being thrown out, but the case still goes on. And other times it leads to the judge deciding that all of the evidence is proper and will come in against you. At that time, again, you have an opportunity to reach any plea agreement with the prosecutor or not. If you don't reach a plea agreement with the prosecutor, then your case will be set for trial. In misdemeanors and gross misdemeanors, at least in Minnesota, you have a right to 6 jurors in a jury trial, and in felony cases you have a right to 12 jurors. If you go to trial, you have certain rights that you'd have to give up in order to plead guilty, or if you have these rights throughout a trial if you do go to trial. Number one, you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. It is your right that carries with you throughout the trial, You don't have to prove your innocence. It's the state's job to prove your guilt. And they have to prove that not just more probably than not, but beyond a reasonable doubt, which is the highest standard of proof we have in all of American law. The other things you have rights to are your right to confront and cross-examine any witnesses that they call to testify against you. So if the government puts witnesses on the stand to testify about what they think you did wrong, you and your lawyer have the right to cross-examine those witnesses and to try to impeach their credibility. You also have the right to subpoena witnesses to come and testify on your behalf, and they have to come testify for you even if they don't want to come, as long as you can properly subpoena them. That's a court order ordering them to come and take the stand in your case. You also have the right to remain silent throughout your trial, and nobody can make you talk in your trial. And you have that right of silence throughout your trial, and the prosecutor and the judge or nobody else can hold that against you, including the jury. So nobody can say, for example, if you decide to remain silent, well, he or she must be guilty if they're not testifying. They can't do that to you. You enjoy the right of silence throughout your trial. You also, of course, have the right to testify for yourself. The risk in doing that, of course, is that the prosecutor gets to cross-examine you, and if you have prior crimes on your record, there's a chance that the prosecutor might be able to introduce those into evidence. So deciding whether to testify or not is something that should only be dealt with after careful consultation with a lawyer. If your case goes to a jury deliberation, you have the right to a unanimous verdict. And the only way you can be convicted and found guilty of a crime is if the jury unanimously, all 6 or all 12, depending on how many jurors you have, all of them agree that you're guilty. If even one of them doesn't think you're guilty beyond a reasonable doubt, then you will not be convicted. If the jury disagrees, and some of them think you're guilty and some of them think you're not, and they can't come to a unanimous agreement, then that's called a hung jury, and that's a mistrial. Prosecutor can go to trial against you again in the future or decide to dismiss the case. And of course, if all 12 or all 6 jurors unanimously find you not guilty, you will be acquitted, and then the state, because of the double jeopardy clause, is not permitted to try you again for that crime. And so that's an overview of the way the criminal process works in most state courts, including Minnesota. In the future, I'll do videos that'll zoom in more detail on each phase of each of these hearings. Thank you. If you have any other questions, my name is Ryan Pacyga. My website is arrestedmn.com. That's arrestedminnesota.com. And my number is 612-339-5844.